Today we're diving into a UK Supreme Court case that really gets to the heart of what it means to be human. It's Nicklinson versus the Ministry of Justice, and it forces us all to ask a huge question. Who really has the final say on when a life should end?
But before we get tangled up in all the dense legal arguments, you've got to understand the man at the center of it all. See, this isn't some abstract thought experiment. This is the real lived story of Tony Nicklinson.
This quote, it just says everything, doesn't it? These aren't the words of someone who just wanted to die. They're the words of a man who felt he'd lost everything that made his life feel like his. He was fighting for one final choice, one last bit of control, and a life that had taken everything from him.
To really get what he was fighting for, you have to try and imagine his reality. After the stroke, Tony's mind was completely fine. He was all there. His thoughts, his memories, his feelings, everything was intact. But his body? It had become a prison. The only thing he could move were his eyes. He called it a living nightmare, and it was from inside that nightmare that he decided to take on the entire legal system.
So this absolutely devastating condition led him to ask the courts a question, a really uncomfortable question, one that sits right at the messy intersection of law, ethics, and our own personal freedom.
And here's the catch-22 he was in. Because he was paralyzed, he couldn't end his own life. He needed someone to help him. But under UK law, anyone who helped him, even a doctor, even his own wife, would be committing a crime, possibly murder. So the question he put to the courts was this: in my unique, awful situation, could a doctor be allowed to help me die without being prosecuted?
His whole legal argument was built on this one pillar, Article 8 of the European Convention on Human Rights. Now, in legal speak, the right to private life is way more than just privacy. It's about personal autonomy. The freedom to make basic decisions about your own life and your own body. His lawyers argued that this right is so fundamental, it has to include the right to choose how and when you die, especially when you're facing a future of what you feel is just unbearable suffering.
This argument set the stage for a huge legal battle. On one side, an individual's right to choose. On the other, the state's long-held duty to protect every single life. Let's see how these two big ideas clashed in the courtroom.
And right here, you can see the two worlds colliding. Nicklinson's side was saying, look, this law is cruel, it's discriminatory, it's forcing me to suffer against my will. But the government argued that changing the law would be a dangerous, slippery slope. They worried it might put pressure on other vulnerable people to end their lives. And this all came from a core principle called the sanctity of life, the idea that every life is precious and the law's job is to protect it no matter what.
So, the arguments were laid out, the principles were debated. How on earth did the 9 justices of the UK Supreme Court find their way through this ethical minefield?
In the end, the answer was a no. The court dismissed the appeal. But look at that vote, 7-2. That split just shows you how incredibly difficult and divisive this issue was, even for the sharpest legal minds in the country. And the most tragic part? Tony Nicklinson never actually heard this final decision. He died of pneumonia not long after a lower court had ruled against him. But his wife, incredibly, carried on the case in his name.
Now, this is the really crucial part to understand. The court's decision wasn't about whether assisted dying is right or wrong. Not at all. It was a decision about power. The majority of judges basically said, look, a massive ethical change like this is not something that we, as unelected judges, should be making. They believed it was a decision that had to be made by Parliament, by the people we all elect. And this quote just sums up their whole reasoning, doesn't it? The Supreme Court essentially said, our job is to interpret the laws that exist. Parliament's job is to make new ones. They felt that an issue this sensitive, with such huge implications for everyone, needed to be debated out in the open by our elected representatives, not behind the closed doors of a courtroom.
So, what's fascinating is that the Nicklinson case didn't really end the debate. It just moved it to a different address. The court took this profound moral problem and handed it right back to society and to our politicians. And it leaves us all with this massive, lingering question. If the judges won't make the call, will Parliament ever find the courage to give us an answer?